Mr. Denne.
May it please the court, counsel. Thank you. Good afternoon. I'm Jay Denne. I represent Jamie Loss as personal representative of the estate of David McFarlin and the individual plaintiffs in this case against the state of Iowa arising out of a boating incident on Storm Lake Memorial Day weekend of 2010, May 31st. The facts of that day aren't really in dispute. As tragic of a set of facts as you can possibly imagine. The facts that really control this case deal with the state's involvement as to this particular dredging operation as the boat hit a partially submerged dredge pipe which caused the fatal accident. Trial court granted summary judgment, and we are here on three different legal issues: the issue of discretionary function, the issue of the public duty doctrine, and the issue of whether or not certain statutes create a cause of action. Contrary to the trial court's ruling, which the Court of Appeals largely adopted, there's some facts in the record of this case in summary judgment, which of course must be viewed in the light most favorable to the non-moving party, the plaintiffs, which indicate that the state of Iowa did have on the ground day-to-day type of involvement in this particular dredging operation. And that is important to the discretionary function argument and as to the public duty doctrine arguments. Again, my impression from the trial court's ruling, again adopted by the Court of Appeals and an argument made by the state, is that this claim, we're trying to make a claim that the state was negligent in dredging in the first place or in where to dredge, particularly in Storm Lake. Again, the specific points of negligence we're making are the on-the-ground decisions. And the testimony from Randy Rettig, dredge operator, indicates that all incidents of boat strikes on the dredge were investigated on the ground by the DNR. Rettig,
clarify something on the facts. It seems to me one of the important issues in the case is the placement of the danger buoys on the dredge line, right?
Correct.
Who put those buoys up?
The buoys are, my understanding in the factual record, is the Lake Improvement Commission, which is the consortium of Buena Vista County, City of Storm Lake, and that particular, they own and operated the dredge, but the DNR itself, if you look at, again, Rettig's testimony, Rettig testified that it was the DNR's responsibility, and they work with them on the placement of the buoy. So the person who put the buoy there was probably from the Lake Improvement Commission, but the testimony was that the DNR
Counsel,
was involved in the placement of them.
Could you point us to the specific line and page that says the DNR placed the danger buoys on the dredge? Because I know there's testimony in the record that the DNR would remove the no wake zone buoys and put those back in, but I was under the impression that it was the LIC that put the danger buoys on the dredge itself.
I don't have the exact. The page number I have in front of me is 393 in the appendix, and I'm not sure if that's answering your question or not.
That's what's cited in your application for further review. But in looking at Rettig's testimony in context, I don't see that he's saying that it was the DNR that chose where to put the buoys on the dredge pipeline.
I'll have to take a look at that testimony in just a moment. I'll address that in the. That's just one piece of the facts that we're relying on in terms of the day-to-day control. Again, we talk about the not only did the DNR investigate after each strike on the dredge, but also with the after this particular incident, the DNR official instructed them to check out this particular dredge pipe.
Counsel, is it true that after the fatal accident brings us here today, that it was the city employees or the LIC that added the additional warning flags along the dredge pipeline?
That sounds correct. Again, that would be after evidence that I don't think, I would say that that's not dispositive of the state's involvement in the day-to-day beforehand, but.
What weight should we give the Winston case, the Lake Sebula, where Judge Malloy for the Northern District applied on summary judgment and held there was a discretionary function immunity for the board that had some involvement in that recreational area? The lawsuit, of course, involved swimmers struck by boats and the claim that it should have been a better buoy marking or ropes or something to separate swimmers and boaters. And that was affirmed by the Eighth Circuit, applying the municipal tort claims immunity, but similar immunity. Should we, why isn't that persuasive here?
I think that was, if I remember the facts correctly of that case, that involved more big picture, whether to put the those markers there in the first place. But there's various federal court cases. Once you've made that decision, that's a public policy decision. I'm not disputing that. Once you've made that decision, there's various federal cases which said, the particular decision as to where to mark buoys is not covered by the discretionary function exception, and that would include McAllister Brothers.
The Olympia case, all the cases out of Indian Towing, McAllister,
Right.
Callis, Sheridan.
Right.
But I want to go back a little bit. I mean, quite frankly, I doubt that once you've made the decision to warn, I don't think, I question whether placement is a discretionary function. That's what the cases seem to suggest. But the question of whether the state was actually responsible for the placement of the warning is, to me, a very live wire. That's where we started out. And I think it's clear from the record, correct me, but it's clear from the record that physically the people who put the buoys out were not state employees. And you've indicated in your brief that Rettig suggested that DNR directed where to put the buoys. So and we'll read Rettig and we'll check that out. But is there anything else in the record that you want to direct us to that would tell us that the state was responsible for the buoy array and not other parties?
The buoy, again, I think I understand the importance of looking at the buoys in particular, but if to look at the DNR was really involved in the safety, in managing the safety of the operation in toto. And so the question is important. It is I understand what you're saying. Who physically put the buoys out is an important question, and I'll look at that testimony again. But again, DNR Copey indicated that he specifically talked to these dredge operators about whether or not to dredge over holiday weekends. He directed the dredge operators to put navigational lights on the dredge because it was completely black at night if those lights weren't on there. To me, that indicates a level of control over the day-to-day actions of this particular dredge. So again,
did the state have any rules or regulations dealing with buoy placement, or any rules or regulations dealing with training?
not specifically as to buoy placement that I'm aware of, Your Honor. Again, it goes back. I think one thing we're kind of been talking a lot about the first and third elements of the discretionary function, whether what was the conduct at issue, and then the third part of the analysis, whether there's any social, economic, or other types of public policy considerations involved. The other thing that we have to look at is that second part of the test, and whether the conduct was discretionary to begin with. Again, 461A.55 indicates that in a dredging operation, that you can't, I'll get the language of the statute here in front of me. Removing material from state-owned waters shall not endanger users of a lake using concealed equipment. Again, you go back to...
Isn't that a policy decision how you're going to not endanger it? I mean, whether you're going to do buoys, whether you're going to close the lake down, whether you're going to put up signs, whether you're going to do this. I mean...
This is on the Schneider versus State indicates that if I understand that case correctly, that it's not, if there's a violation of a statute, It's not discretionary at all. You have to follow
Isn't it
that.
discretionary how you carry out the statute, though? I mean, I understand they had a duty to do it in a safe manner, but isn't it a discretionary policy of how they're gonna do it? You know, are they gonna close the lake down? Are they gonna put signs up? Are they gonna put buoys every 100 feet? I mean, I think you're sort of talking in circles here, and maybe we're talking between us, but, you know, just, you know, if the statute said you put a buoy every 100 feet and you put a sign every 30 yards or something, maybe it's different, but just a general thing to be safe has to leave somebody a decision or discretion to do it. So am I wrong on that?
Well, look at the Messerschmitt case. That involved just a placement of a barricade on a city parade. You know, to me, that's probably the closest analogous case from this court when you're dealing with a protective barricade in a parade. You're dealing with a mooring buoys out on a lake.
But in that case, the city put the barricade there, right?
Correct.
See, the issue here is, it just kind of my flavor from reading the record is DNR is more like a cop on the lake, and the dredge is owned and operated by this commission. And normally, you know, if I like park my car in the road and it's in a dangerous position or something, it's endangering other motorists, and the cops don't tell me that I need to move it, you can't sue them, you can sue me. Isn't that right?
True, but again, the distinction, the facts that I just gave to Justice Apple in terms of you have evidence of actual DNR control over what was going on with that dredge operation on a particular safety items, particular day-to-day type of operations. So this isn't the cop that just neglected on one occasion where you kind of just abstained from doing his duty. This is a case where there was actual control over that particular.
Could you address the public duty doctrine, which seems to be to live on in the restatement third? There's comment G to section 7 that has a string cite of cases, and so.
And that's why I didn't raise that. You have to pick your battles in these kinds of cases. So
All right.
Assuming arguendo that the public duty doctrine did survive because of those comments in the restatement third, and I think there's case law which indicates that as well. The argument we have that the public duty doctrine is not dispositive of this case relates, again, the district court largely determined that the public duty doctrine, again, the court was looking at the overarching things that the state did and not found that there was no evidence of day-to-day type of control over the dredging operation. Then the other, and these are cited in my brief, I would say the case against the city of Des Moines, I believe it's the Sumi case, if I'm not mistaken. Yeah, Sumi versus City of Des Moines talks about the duty to people who come over your property, and of course, going all the way back to Peck versus Alfred Olson, the state does have a duty of maintaining and promoting navigation of navigable ways in the public waters.
Going back to your argument that, you know, they're the sort of enforcers of keeping the lake safe, you know, and we're intimately involved in this day-to-day dredging operation. But then again, it seems to me it's up to the DNR of how much resources they're going to put on this lake versus the other lake, what their budget considerations are. I mean, I could see all kinds of social and economic decisions made by the DNR just to patrol the darn thing. So where do you...
Schmitz versus Dubuque. Cost does not satisfy the need to show social, economic, or discretionary function. The cost.
But the policy about maybe I'll put three people here and 4 people on Okoboji and 6 people on Spirit Lake. You know, they have lots of lakes to watch. I mean, just the personnel.
Right, and I'm not complaining they should have more personnel. Again, we're talking about the specific things that are in our plaintiff's experts report. Again, a lot of it dealing with the markment of those buoys, and again, under the various federal cases I've cited in the brief, I believe that those are the appropriate cases for this court to follow.
The Is this case like Sumney, or is it more like Colby, where, I mean, who are the people protected by the DNR? They have to let everybody use the lake, right?
Correct. But again, they were given they have a specific duty to protect those who navigate the water, and then various restatements that indicate they have a duty also to protect when they allow other people to use those waters.
And does public duty apply to common law torts?
Public. That's our first argument. Is that thank you. That would deal with the statutory claims we're making. I would argue that it doesn't apply to the common law negligence claims we're making. I'm over time. Thank you.
Mr. Denne, thank you as well. Ms. Updegraff.
May it please the court. I'd like to go straight in and talk about the second prong of the discretionary function immunity, because I think that that may be what this court is mainly concerned about. It was certainly what I was concerned about when I raised the discretionary function in the district court, and I specifically pointed out to the district court that I was concerned and unsure of the holding in the Walker case and how that may apply to the actions in particular of Officer Copey, who is the DNR officer. I think under the Walker majority analysis that the actions by the DNR various officials do satisfy the discretionary function. The plaintiffs have not pointed to any, first under the first prong, they haven't pointed to any statute or regulation that mandates any particular type of action on behalf of any of the DNR officials involved. And under the second prong, Officer Copey's actions cannot be looked at as an ad hoc decision tailored to the particular circumstances in front of him. And I don't believe that the plaintiffs are claiming that. They're not saying that on the 31st of May in 2010 that Officer Copey failed to take any particular action, such as knowing that the dredge was operating that day. They're really challenging 6 years of decisions that have been made at various policy levels.
Oh, wait a minute. I'm most troubled by the placement of the buoys. I mean, there's a number of there's permitting issues and a bunch of issues, and I'll let that rest in the briefing. But the allegation is that the buoys were poorly placed and they misled boaters. And I know you have a factual defense to that, but of course that's not what we're here for on summary judgment. If it is true that those buoys were poorly placed, it's hard for me to see how that's a discretionary function under prong 2. There's no social economic purpose behind misplacement of buoys. And there's a whole string of federal cases that seem to stand for the following proposition. The decision to place a warning regime might be discretionary. The decision to build a lighthouse, how much money do we have, da-da-da. But once you put it up, at that point, the manner in which the warning is made to the public is not a discretionary function. Same is true with the Northern District of Iowa case. I mean, there was no warning out there at all, and whether or not to put a warning regime at all out there might involve economic considerations. But here, the warning, there was an acknowledged warning regime. And according to the plaintiffs, it failed. It's hard for me to see the social and economic policies that were behind the failure to place a couple more buoys or the failure to place a couple more flags once the decision had been made to set up a warning regime. So show me how I'm wrong.
I think that your analysis is too narrow. I think the discretionary function, even under the second prong, that it assumes there's a duty. It assumes something can be done negligently.
What's the social and economic policy that prevented them from flagging this thing? Is it cost? Is it? I mean, I understand when you don't have enough money to build lighthouses, we have a $10 million federal budget, and we have a need for 200 lighthouses, we can only build 10. I mean, I get that completely.
I think that social, economic, and political policies at issue here, and if you want to look exactly at the placement of the buoys, is that Officer Copey at various occasions had tried to suggest to the dredge operators that you do not operate the dredge. Actually, it's even more specific than operate. You can operate the dredge, but I really don't want that pipe on holiday weekends. So he did make an analysis. He did say socially, there's going to be more people out and about. I want you not to be floating that
Let's
pipe.
try and, you would, I understand your point that in the briefs, that you don't own or operate the dredge, and therefore you don't have a duty to place the buoys appropriately along the bridge. But would you agree with me that if the state did own and operate the bridge, that the placement of the buoys would not be a discretionary function?
I do not, because that all is embodied in this whole process of deciding to dredge, deciding where to dredge, which is a conservation type of an issue.
Oh, I agree with you on that.
Once you
actually.
make that decision, though, you're going to dredge, you're going to do this and that. I mean, the officer is confronted with a situation, just like in, I think, of the Walker case, an ad hoc decision of whether or not we're going to put the warnings or the buoys or the flags on this pipe or where this pipe is based upon the circumstances on that day. I mean, it doesn't have anything to do with, tell me why I'm wrong. What does it have to do with placing it on that day or at that time? Discretionary function.
The buoys aren't placed on a day. The buoys are placed once a year when you take the dredge operation back out. They're placed and they're there. It isn't a day-to-day thing that the buoys are placed. The buoys are placed at one point in time, and the DNR, including Officer Copey, did not have the ability to stop the dredge from operating because it's permitted. The buoys did not violate any particular regulation. This is a public lake. The public has the right to be in this lake, and to close down the lake part where the dredge operation would effectively close down 1/3 of the lake.
Counsel, how is following up on that line of questioning, how is the adequacy of the placement of the buoys in this case any different than the barricade in Messerschmitt? The court, as I recall in that case, said once you decide to make the determination that it needs to be barricaded, how you decide to make it safe with a barricade is not a discretionary function. And isn't that the same as the decision whether to put the buoys every 100 feet or every 1,000 feet?
I think in Messerschmitt, the problem was when the city decided to remove the barrier, not necessarily when they decided to put the barrier up. And the barrier being removed was an ad hoc, that particular circumstance decision. I think the distinguishment here is that the plaintiffs are not only talking about the placement of the buoys, they're challenging the whole permit process.
Well, you
and the
may win
reason-
on that ground. I mean, quite frankly, whether or not the permit should have been issued is, for me, a completely different issue. And indeed, it seems to me the plaintiffs have raised a number of specifications of negligence. Under our framework, we have to go through each one and analyze the conduct. First thing is identify the conduct, and there's 8, 9, 10, or their expert has, some of it's duplicative, but like most experts, she has multiple theories. One of the theories, though, and I want to again go back, is that these buoys were in the wrong place and that they were misleading. That's the conduct we focus on, not the permitting. Permitting is a different theory, and as I say, frankly, you may have a stronger case on discretionary function on permitting. But at the placement of the buoy level, setting aside the question of who was responsible or who owned, but assuming the state did, wow, it's just hard to see that there's a social or economic policy. It's like putting the lighthouse a half a mile back, and when the merchant ship crashes on the shoals, The government says, well, we misplaced the lighthouse, but that was a discretionary function to put it back half a mile. And because they're, well, I mean, it looks like this was a mistake, arguably. That's what the expert says, at least. And you may win on the merits, of course, but the expert says the buoys were improperly placed.
And that expert can't tell us how those buoys should have been placed in order to prevent this tragic accident. But Officer Copey's decision whether to try to attempt to make the dredge operators change their buoys in some...
I understand that argument. That's different. But don't you agree with me that if DNR really had the primary responsibility for the location of the buoys, that would be not a discretionary function? I mean, I think Justice Apple is right. There are cases that don't support you.
Sure, there's cases that don't support me, but there's cases that do on the federal level that I've cited in the brief.
But most of those actually involve decisions not to warn. I mean, that's like the Northern Iowa case, the Winston's case. I mean, it was a swimming beach, and there was no warning. The fact is there was a beach there, and kids and adults apparently splattered around. And one could at least argue, well, I mean, it's going to cost a couple $1,000s to put up whatever nylon, whatever we do around beaches, and we have 500 of them that could qualify, and da-da-da. That is a discretion. But once you decide to do the warning, once you have a duty to do it carefully and reasonably.
I think in the Winston case, they weren't looking at whether or not the decision as to whether or not to put buoys. I think the Winston case looked at it much broader in that we have all of these political entities on several different levels.
What's the politics of putting out 2 extra buoys and a couple extra flags? I mean, I don't think there's any politics at all in that.
Well, there's social and economic.
What about, I mean, so under your theory, the commission would be entitled to summary judgment, right? They paid a lot of money for nothing, right? Under your theory.
The LIC?
Yeah.
Well, the LIC isn't a governmental entity entitled to discretionary function immunity.
What claims are barred by the public duty doctrine in the state's view, and which are not?
The district court found that the claims of arising out of statutory duties were barred by the public duty doctrine. I think that the common law claims are also encompassed within the public duty doctrine, although that wasn't the ruling of the district court or the Court of Appeals. But I did argue that at the district court level that the public duty doctrine would be also applicable to the general common law or premise liability type issues, and that's simply because that duty again would be owed to the public in general and not to any particular individual.
Wow,
in this case,
so if you get hit in an automobile accident by somebody driving the truck for DNR, that's a discretionary function because the duty is owed to the public?
no, I wouldn't say that. I think that there's been case law that says that public employees that are driving vehicles don't get the protection of the public duty doctrine or of discretionary function.
But if a highway patrolman stops a motorist who's got some faulty equipment and lets him continue, and then there's an accident, is the state protected by the public duty doctrine there?
Yes, and I think that is very close to the Hildenbrand case that I cited, where there was a gentleman that was driving and he was intoxicated apparently and ran into a flower pot. The police officer let him go, and he later on crashed, and I believe he killed himself. And that suit said that is a law enforcement, and that you cannot have a particular action for that because the law enforcement's duty is to the public in general and not any specific individual. Was
it different on Storm Lake? Do we take a narrower view of the public because it's just a smaller number of boaters?
I do not believe so, Justice. I think that the analogy that the district court and the Court of Appeals made to the lake, to the highways, is particularly good. in that we have highways that the general public is entitled to use, and we have public lakes that the public is entitled to use.
What do you make of the premises liability claim? The lake is, and the lake bed is owned by the state, I gather, and does the public duty doctrine defeat premises liability claims?
Yes, I believe it does. I think the public duty doctrine would, the premise liability, it would be analyzed the same way. And I also think
If I trip outside, again, I mean, if I'm out on the courthouse steps here and there's some hidden hazards and so forth, you'd say, well, public duty, and therefore no collection?
well, I think the Hoover building is a lot different than the highways or,
Then the lake, I mean, the lake is like a
The lake.
park. It's like being on a park that the state owns.
it's a public resource. It's a lake that's held in public trust, and the administrative codes support that. It's not the same thing as this building or my building across the street because of the nature of it. It's the lake is for the benefit of the public.
How would you distinguish the Sumney case, or Sumi, where the city-owned golf course, our court declined to apply the public duty defense?
Right, that's a golf course that's been operated by a city, and I think you're definitely an invitee onto the golf course. You wouldn't have, as a member of the public, I wouldn't be able just to walk onto the golf course and start golfing. I would have to be a member or pay a fee or however that works. And so I think that's a clear distinction between a golf course where you may pay to enjoy that versus a public lake where anyone is entitled to use it. Thank you.
Thank you as well, Ms. Updegraff. Mr. Denne, you may present your rebuttal.
Thank you, Your Honors. I had a chance to check a couple of things out in the appendix. As to the testimony of Rettig, 2 pages in the appendix are going to be important in your review, page 393 and 397, which it's got those scrunched transcripts, so it's got 4 pages apiece. But Rettig, it's page 83 of his deposition, which is on appendix 393. He does talk about buoys. Now, in this particular context, he's referring to the no-wake buoys around an island. He says, based on your experience in the lake, is there a no-wake buoy or several no-wake buoys in the vicinity of this little island, which there was a little island right next to where the boat went as it was heading out into the open lake, or this dock? And the answer was there usually is during the summer months. It depends on when the DNR puts them out. So that's some direct testimony from.
But that's with regard to the no-wake buoys, right?
No-wake buoy. That particular testimony is the no-wake buoys. But I think, again, this is the overall, more evidence of the overall control of the DNR, which is confirmed at 397 when Rettig is testifying that the DNR confirms that they're doing everything they're supposed to be doing, that everything looks okay out there, and they're it's sort of a they're assuming so anything that the Lake Improvement Commission, the dredge operators are doing, the DNR on the ground is saying, yep, you're doing that just fine. So again, all of the facts put together, I think, show that kind of day-to-day control on the ground that would result in the discretionary function exception not applying. Just as to the public duty doctrine, I think I addressed that before, but again, the issue of whether Ms. Updegraff is saying, well, that really does still apply to the common law claims as well as the statutory claims. Again, that was a finding of the district court that there's been no cross appeal on that issue. I don't think that issue is before the court, and I think considering the evidence in the light most favorable to the plaintiff, including the holding in the Sumi case.
When the state won below, they don't have to cross appeal. In fact, they can't cross appeal. you know, that's why I think the Court of Appeals got it wrong when they said the recreational immunity or use statute, air wasn't preserved because it was argued at the trial court. They won on other grounds. They don't have to cross appeal. So whether they're on the merits, they're right or wrong, isn't it fair game for us to decide that legal issue on appeal, even without a cross appeal?
It could be. I don't think it's been, I don't know if that was specifically briefed. I know it was a distinction that I made in my brief. I don't recall if they made that argument in their brief or not. So I would, if they did not, I would argue the old adage that if something that wasn't addressed in your brief is thereby waived. I think I've said about as much as I can say, considering the extensive briefing in this case. I'd be happy to answer any further questions.
Mr.
Thank you, Your
Denne,
Honors.
thank you. The case then is submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.